that this appeal has already been admitted, and if your lordship reads the last order, 27/2020.
You are ready.
My lord, paper book has not been.
Furnish the paper book in the other case. It
No,
will help.
that will help. That is the same.
That is the only one.
Yes, but we have not been furnished with that.
We'll ask you. Yes, madam.
Otherwise, also she is behind the bars for long. In that case, that
You have
person has
boarded
been-
the bus late. You have boarded the train late.
I am amicus for the. And
Yes, madam. File your file. File your.
in that,
Hard Mr. A. Planet Mike Askew. Corda. Accused appellant. And Miss Iregon. 302. Learned Council, Learned Additional Public Prosecutor, Respondent State. This appeal from jail is preferred against a judgment an order dated 19 judgment dated 19/5/2016 and an order dated 23/5/2016 passed by the Court of London Sessions Judge Kamar P. In Sessions case number 46 in bracket T of 2010. Close. Param. I don't know, by the oh, parameter. In the trial of Sessions case number 46 bracket T, 2010. Two accused persons. One, Binu Mahato. Within bracket accused appellant Herring. And two, Mania Munda. Face the trial for charges framed under sections 444 stroke 302 stroke 34 comma Indian Penal Code pursuant to submission of a charge sheet dated 36/2008 in connection which Tinsukia Police Station case number 25/2008. The charge sheet was submitted by the IO finding a primary case for commission of the offenses under sections 448, 30234 IPC against four number of accused persons. One, Srimati Arati Tati, two, Sri Binu Mahato, accused appellant here in bracket. Four, three, Ganesh Tati, and four, Mania Munda. Post. Two accused persons named Arati and Ganesh were found absconding and order of execution for proclamation and arrest were issued by the London trial court. Those of the London trial court had thereafter proceeded to continue with the trial sessions case number six, wherein the two accused persons, Binu Mahato, and Sonia Munda were tried. After conclusion of the trial, from the impugned judgment in order was passed by the London trial court. Subsequently, the convicted accused from Monia Munda preferred a criminal appeal from jail, which was registered and numbered as criminal appeal number 53 within bracket J close stroke 2016. Close to.
Judgment dated 11/12. Yeah.
By judgment and order dated 11/12/2019. The criminal appeal preferred by the convicted accused, Mania Munda, criminal appeal jail number 16 was allowed. Setting aside the conviction and sentence passed against the said accused, Mania Munda. The present accused appellant, was charged for the offense under section 302 IPC in aid with section 34, IPC has referred this criminal appeal. The learned counsel for the parties have submitted that the paperwork prepared for the connected criminal appeal, criminal appeal J number J number 53 of 2016 would be would suffice to hear the present appeal. Correct. Registry to furnish a copy of the paperwork prepared in criminal appeal jail number so and so to both Mr. Dhor and in America Security and to Ms. Begum and submitted by day after tomorrow,
Monday.
Thursday. Case by case. As the appeal is already admitted for hearing. Come on, raise the case for hearing. But he come prepare with the full judge.
I have been engaged privately in his appeal also. So copy of the paper will be furnished to me also.
How to? Wait, wait.
Yes, Lord.
Copy of the paper is to be furnished also to Mr. Anderson, learning council. Stated that he is here, he be appearing for the appeal. But don't come empty handed,
Lordship.
come with law. Come with law, don't come empty handed. No, I inquired, it is not so. But, this appeals from jail is directed against a judgment and order dated 12/3/2024 passed by the Court of Planet Special Judge within bracket Foxo Vishwanath at Vishwanath Sareli in special in bracket Foxo case number 04/2019. Special court bracket. By the judgment and order dated Planet Special Court. As convicted, the accused for the offense under section 4 within bracket 2 Foxo Act, and he has been sentenced to suffer rigorous imprisonment for 20 years and to pay a fine of rupees 10,000 in default of payment of fine, to suffer rigorous imprisonment for another 3 months. Also, the appeal be admitted for hearing. The trial court reports also be called for issue notice returnable in 4 weeks as Ms. Begum granted has appeared accepted. Also, as the instant appeal is preferred from the registry to appoint an amicus curiae, amicus or legally counsel, amicus curiae, for the appellant to represent the case for the appellant. If you have a question, exception, so or practice direction, harassment number, two stroke information. Practice direction. Hard Miss D for project. And amicus or legal?
Legally.
Legal aid counsel for the appellant. And yes, the Begum petition for prosecutor for the respondent. Also,
No,
or 302,
302.
respondent state. This criminal bit. Under section 415, Bharat, correct on it. Is directed against a judgment in order. Dated 11/11/2020. Oh, sorry, judgment dated 5/11/2024 and sentence dated 11/11/2020. Passed by the Land Sessions Court. So I do, as to not in Sessions case, Sessions SAR is the. Also by the judgment, by the judge, say judgment in order, the land trial court. As you are one of them,
Lordship.
Hmm?
There are 3%.
Ah.
Lordship.
has convicted. The accused appellant along with two others. You are A1, A2, A3.
3, Lordship.
A3, put in it, along with two others. For the offense, this under section 302, 34, sorry, 34 stroke 201. So the appellant has been accused of sentenced to what is the sentence?
Lordship. 74, Lordship. Last page.
70.
Lordship, last page.
So what is the sentence? That is conviction.
Lordship. Sentence is page 11, Lordship.
Page. For the offense under section 302. IPC. Comma. Read with section 34. Comma. The accused appellant has been sentenced to undergo imprisonment for life and pay a fine of rupees 10,000 in default of payment of fine for 3 months. The appeal is admitted for hearing. Issue notice returnable in courts as MS. Begum. Any private respondents?
No, Lordship.
Records of trial court. Yes, LJB. Then legal aid counsel for the accused appellant. And as a Begum, the public prosecutor for the respondent number 1 must take it. Also, this criminal bill is under section 415. We make it 2 or which is directed against the judgment and order dated 13/3/2025 passed by the Sessions Judge Hemaji. In Sessions case number 26. Stroke 23, arising out of Hemaji Police Station case number 39 stroke 2023. By the judgment and order dated such. The trial as convicted. The accused
In the section.
appellant for the offense under section 376 within bracket small f, Indian Penal Code. And he has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of 30,000. In default of payment fine, to suffer rigorous imprisonment for 3 years. The appeal is a hearing. The case records of Sessions case number 26 of 2023 for court. Issue notice returnable as Ms. Begum. One, the petitioner selects, sorry, the appellant selects for service of case upon the respond number 2 stroke victim or informant victim in terms of the practice directions of students service report from emergency station. Is there interest?
There is a type of misconception in the address of the informant victim. It should be Hemaji. It is mentioned in the
Is there any other address? No. Somewhere?
what it is. The type of
Yes,
address
Devi
should
Lan-
be Hemaji.
Am I correct? I have submitted that an inadvertent error has taped in the address in the cost type. And as regards the address of the respondent number 2 stroke victim in the cost type. So as David has submitted that instead of district Morigaon, comma should have been district by the steps for service of notice upon the respond number 2 is comma therefore comma to be taken and the address district Morigaon technical level.
Steps that have been taken by file of it as required by us.
Which one?
76.
What does the practice direction say?
It says it is only for 376 AB, 376 TA, or 376 TB.
Okay.
And
After register process as well as by usual process.
If the present matter is in practice. It's still in practice.
This is particular observation.
No, your lordship, because we are praying that we may be released and deport as per law, but in the meantime, we have received reports that they have been pushed into Bangladesh. So hence, nothing remains.
Heard Mr. D. Khan,
Yes,
learned counsel for the petitioner, and Ms. L. Devi, learned counsel. Presenting R. K. Dev Choudhury, learned Deputy Solicitor General of India for the respondent number 3, 4, and 5. Also heard Ms. The state. Any state council? Call someone. Mr. Khan has submitted that the subject matter of the petition has become infructuous and you are a petitioner, you filed a petition for another one, right?
yes, your lordship.
The petitioner's brother
Yes,
has, in the meantime, been pushed back to Bangladesh,
yes, sir.
has been pushed back from India.
Yes.
In view of the above submission made by Mr. Khan and counsel for the petitioner, very. It's a signature.
Your lordship.
pending criminal appeal. I have been filed for suspension of sentence way back in 2023, man.
Offense,
Offense 302 by 34, man.
30.
34. Other than the son, man, there's a field, man. There are details so far as the commission of the offense are concerned, question of appreciation of evidence. But medical ground, I have filed one of this. So far as the
Medical
other-
ground, what
Yeah.
kind of medical ground? Very serious.
very serious, but she had a fall in the jail, man, bathroom, man. And she sustained patella injury, man.
Patella means what? I don't know. I'm not very conversant with medical terms. Injury bathroom, sustained patella.
Yes.
What is patella? Femoral block.
Knee, the
Knee
leg
kind.
was, yeah.
Facilities are there.
Therefore, she was operated, madam. She's around 65 years of age. And now 67 years.
Later you, let us see the evidence. Let us see that. Yes, who are the witnesses?
Witnesses are minor, they are actually,
Yes, Begum,
Lordship, LCR is there, Lordship. Paper,
Ah.
paper would be there, that would be harder. Like,
let us have a glance.
last minor, the eyewitnesses are there, my lord. There was, Puspa Borwa, Timothy, Nirupa Gogoi, man, Mukul Gogoi, man.
What you can say?
Applicants are, my lord, what are applicants, my lord?
What is the name?
They are,
Deposit Gogoi, British.
Devori Gogoi and
Deposit
Rupa
Gogoi,
Gogoi.
British and
Rupa Gogoi,
Rupa Gogoi.
mother and son. Allegation that against this Rupai, my lord, he brought the sword in a Mekhala Sabha, man, for causing death, man. That is the allegation. And handed over to the Devori Gogoi. The Sadar she brought it. On top of one. There was an extramarital affair actually. Result of that settlement.
What happened? Oh, father,
Sadar, yes.
34 is
Adipuri,
here.
yes. Adipuri. That is a specific act
at
attributed.
least I have just seen one and three.
Yes.
Six also.
Six, yes.
Six also.
Yes.
Very damaging. All I witness.
They are in the same family, madam. It's inside a residence, my late, I think.
Privacy, there is no case, at least at this stage. 1, 3, 6, clear evidence.
Yes.
And you have existed.
Yes.
British. Not British Empire.
Actually, that sword was bought, actually, it is a case of private defense. But
And what is the postmortem? It is consistent.
yes, there was an injury, my lord, that is.
External injury. Sharp cut.
Sharp
on
cut
the
injury.
left side of the neck.
Yes.
Consistent. Neck. Yes, Mr. Kotogi.
So maritime, only on medical ground.
Medical, what is, tell me patella,
Patella, my lord, they are,
medical is.
they are in that, that,
In Assamese, I can understand. But not in English. What is the spelling? Patella. P-A. T.
PATE.
A, P, A, R, S, E, patella. The lens shape bone that forms the kneecap. It is situated in front of the knee in the tendon of the quadriceps muscle of the thigh. The flexor of the patella.
Fracture of patella, we fell down in the bathroom, my lord. So considering the age and also the injury sustained, my lord.
At this stage, no. You are the active perpetrator. She witnesses said, you have brought the charger, meaning that the intention was more in your mind than your son.
I understand.
Otherwise,
Yeah.
how in a quarrel,
Right.
somebody
Actually,
will
my son was assaulted, man. That part has not come. That is the
coming paired with a sword, the mental
element is there.
element is quite clear. With a torwal, not with a lathi. Had it been a lathi, for a time being,
Yes. Okay.
art is the peak of the Did I observe something or should I?
Oh, you want to come out of let him come for, let the paperwork will be ready and go for
Alright.
hearing. That will be the best.
Mr. P. Popo, learned applicant. Learned also for the applicants and Miss A. Rego, learned petitioners. Public prosecutor for the opposite party from a state of Assam. Para. It's an application under now how to follow the procedure? It should be BNSS or 389.
So that was filed prior to
Okay.
enactment of BNS.
It's an application is preferred under section 389, Code of Criminal Procedure. Seeking suspension of execution of the sentence passed against the appellants in a judgment and order of conviction and sentence passed by the learned session judge Sipsagar, case number Sessions case 99 within bracket SS stroke 2018 and for their release on bail. Close stop. Para. The applicants as the applicants have prepared the connected criminal appeal from a criminal appeal number 256 of 2023 against a judgment dated 9/6/2023 and an order on sentence passed on 2/6/2023 by the learned session judge Tibohaga in sessions case number 99 says of 2018 close stop. By the judgment dated 9/6/2023, the learned trial have convicted both the applicants for the offense under section 302. From IPC review, section 34 IPC. By the order on sentence dated 2060,000, which applicants have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 each from a default payment of fine, or to undergo single imprisonment for another 3 months each. There are Mr. Kotogil and also hearing for the applicants submitted during the while undergoing the sentence. The applicant number 2 has sustained injuries on 9/12/2023 as his bill in the jail bathroom. Full stop. The applicant number 2 was thereafter admitted in the Assam Medical College and Hospital, Dibrugarh. And later on, she was discharged on 22/12/2023. Full stop. She had sustained fracture injuries of patella. Full stop. So, Kotogil has further submitted that considering the age of the applicant, the case of the applicant number 2, applicant number 2, on the case of the applicant, 2 applicant may be considered sympathetically. As further submitted that both the applicant appellants have been undergoing sentence since the judgment in order of conviction and sentence. Ms. Begum, the application being for the state has maybe objected to the. Did you file objection or not?
It's on my level file, madam. And on merit, madam.
Has vehemently objected to the prayer measures in this application, contending that there were eyewitnesses to the incident of assault. And the eyewitness says testimony was duly corroborated by the medical evidence, which are in the form of the testimony of the autopsy doctor and the autopsy report. We have gone through the trial court reports were called for and have been received. Also, we have gone through the materials available in the case records of section case number 12, so in origin. So, during the course of the trial, the prosecution side examined 11 number of witnesses and exhibited 12 number of documents. In addition, material exhibit was also exhibited. Poster parameter. The prosecution witnesses, PW1, PW3, PW4, PW5, and PW6 in their testimony had clearly implicated both the guilt appellants in the act of assault on the deceased by A.S. Ford. Their testimony on the point that the applicant number 2 had brought a sword, the released weapon of assault, by keeping it to the place of occurrence, by keeping it hidden inside her charger. As soon as the quarrel took place between the applicant appellant number 1 and the deceased in the courtyard of their house, of the house of the deceased, house of the deceased, the applicant appellant handed over the sword to the applicant appellant number 2, to the applicant appellant number 1. The applicant appellant number 1, by taking the assault, the sword, the weapon of assault, inflicted a blow on the left side of the neck of the deceased. The autopsy report, within bracket EXT2, had recorded a sharp cut wound over the left side of the neck, just below the angle of mandible, is 28 out of 7. 6 inches or centimeter into 2 inches into 2.5 inches. The autopsy doctor, within bracket PW2, in his testimony has opined that the cause of the death, the disease, was due to syncope, within bracket shock and hemorrhage, as a result of the injuries sustained by the person, by the person, sustained by the person, for the wound caused by a sharp cutting weapon. He had testified that the injuries as found on the neck of the disease was sufficient to cause death of a normal person, and apparently the nature of the death was homicidal in nature. Having considered, having taken note of the testimonies of the eyewitnesses and the medical evidence, we do not find a privacy case to consider the plea of the applicant for suspension of where the sentence passed against them and for their release on bail, at this stage. The injury sustained by the applicant is found to have received due medical attention. The applicant appellant was treated in Assam Medical College and Hospital. Close up. The it is observed that if the applicant appellant needs any further treatment in connection with the injury she has sustained at Patela, command the jail authorities shall do the needful to provide proper medical attention and treatment to the applicant appellant. In the appeal. Hard Mr. People and also for the appellants and Mr. A. Venu. For the state. As the records from the trial courts have been received, command the registry to prepare the paper expeditiously later release the case appeal after 4 weeks. The report as regards the paper.
People Lordship. Lordship, as per the office note, the paper has been received. The LCR has been, tried.
Let it be connected with that appeal. Both the appeal, the criminal appeal number 195, how many persons were convicted?
One.
Huh?
1 minute.
No. Page 50, come to page 50. This is the judgment. 6 persons, 6 accused to the trial, right? How many have been convicted? How many?
Appealing for one, Mr. Dipon.
Right. How many have been
One,
convicted?
my lord. If your lordship comes to my paper, appeal memo,
Now,
page
who has
14,
preferred this 195? Criminal appeal themselves.
maybe
All are
against
acquitted.
all are acquitted except one.
Huh?
I am for the convict.
Right. Criminal, Arisa. Criminal appeal number 195 of 2000. Appeal. Maybe appeal against the
Acquitted, has to be appealing.
records are connected there. Get it.
This may be tagged and paper.
Right. Mr. D.K. Bhattacharya, for the applicant and Ms. K. Begum, connected. By this appeal is referred against the judgment and order dated.
11, 10,
Judgment dated 11/10/2023 and an order on sentence dated 30/10/2023. So in past in sessions case number 77/2018 by the Court of Additional Session Judge Barbados. First of, in the trial of sessions case number 77 of 2018, 6 accused persons, including the present accused appellant, stood the trial. First of, after conclusion of the trial, the three, four, five. The other five accused persons were acquitted from the charges under section 302 stroke 120B from IPC. Also, it is only the present accused appellant.
There was some delay in my while filing.
That is different. See whether these are your
Connect.
alleged partner in crime. The respondents, I don't think. Something is wrong.
The lordship takes up page 14 of my appeal. All the other documents.
You see the respondent. Do you think that they are your alleged partner in crime?
No, madam.
So there
Others are
may
Sanjeev
be
Bani.
something wrong.
So they are not given, Sri Nepal Bani, Srimati Rakshi
Something
Bani.
wrong.
Maybe.
Some Bosu Motaris are here.
Lordship.
Madam, the other co-accused are named in page 14 of my memo.
I have seen.
All are
I
Bani.
have seen, I have tallied. They are different.
They are different.
But they are responding in criminal appeal number 195 of 2026. And office note says your trial court record is tagged with 195, criminal appeal 195, 2020. That is a difficulty. Let it be listed, thereafter we have to do it. Because of Sessions case number 77.
77 of 18.
Let it be. You have mentioning this. It's a different, some Anthony Rompi, Augustine Rompi. Page 30, second page of the judgment, third page.
14, page 14.
On the office notes dated 15/5/2023-25. As per office. A letter is received by the registry from the Court of Learned Additional Session Judge Boffitt stating that the original trial court records of Sessions case number 77/2018 has already been transmitted in connection with criminal appeal number 195/2023. Let me check. Oh, wrong again.
24, I guess. Maybe.
Yes,
Has to be.
see, for their fault, we have to spend time.
195.
195 of 2000. Mistake for the document going lost of time. 195 of 2020. See, somebody does the mistake we spend is for that. From flag A. Comma, which is a letter.
That is also not correct.
Huh?
That is also not correct. One, the website shows that it is from Jorhat. The appeal is arising out of a judgment of Jorhat.
Bijoy Pan Tati,
Yes, Jorhat.
York, Jorhat.
Jorhat. And this is of Orpeta.
As per office note dated 2025, from my letter received that is from the additional session just brought it up, stating that the original trial court records of sessions case number 77 to 2018 has been transmitted the registry connection with criminal appeal number 195 to 2023. Full stop. The on from the CIS, comma, it transfers that first one, 2023. Transfers that criminal appeal number 195 to 2023. Does not refer to any of the parties involved in sessions case numbers, for instance. Also, on perusal of the contents of tag A, comma, which is a letter from the additional session just brought it. Comma, it is noticed that the case records of sessions case number 77 to 2018 has been transmitted in connection with criminal appeal number 23 of 2020.
This is present appeal. 23 or 24 is my appeal.
Okay. Oh, one minute. Put it. Put it. In connection with criminal appeal number 195 to 2000. Office to examine the case records sorry. Like examine the case records of criminal appeal number 195 to 2020 to find out whether the case records of sessions case number 77 to 2020 is tagged therein as the said case records is relevant for the instant criminal appeal. So, I'll raise the case.
How much? Happy village. So here the claim was convicted under section 302 for imprisonment of life and fine of rupees 2,000. Since 22/5/2024, the appellant is behind the bar. So I was also preferred for suspension of sentence by law. Therefore, is there.
Objection filed.
Objection has already been filed. On merit, they have filed an objection also.
Here is here.
So before that, was it for consideration of IO lordship, IA, was it there is no prima facie case. If your lordship kindly go to the evidence on record, there is no prima facie case against the accused. to convict him under section 302.
How many accused?
Lordship Singh, 180. Another. Date of incident, my
Case
lord,
of direct evidence or
no, my lord,
circumstantial
no, my lord.
evidence?
Circumstantial evidence. That too, my lord, the learned trial court has relied on the oral writing declaration, which is not consistent at all. No witnesses have in their previous statement before the IO have stated regarding anything regarding the dying declaration. Subsequently, for the first time, before the court, they have stated that there was a dying declaration, oral dying declaration. And that is the proof contradiction from the IO. Notable kindly see the date of incident on 13/5/2024.
See the medical.
Lordship. 75 to 80% of the bond. The victim. I will be present of a note in one snake, both breast, anterior abdomen wall, genital, parts of the pec chest and abdomen. Ensure medical aspects of both the arm, both forearm, both hands, both thighs, both leg, part of the both feet. The base of the burn areas are covered by unhealthy delusion tissues and greenish color, past and present, shining of the hair present on the genitalia and axilla. The burn injury covered 75 to 80% of the total body surface area and epidermal and dermoepidermal intact. This is the injury shown. And the opinion part also, that was due to septicemia following the burn injury, which covers 75 to 80% of the total body surface. And the informant is the husband of the victim also. He was working outside the state. So he came on 16/5/2014. And on the same day, he was told by the victim that the accused appellant has set fire on her. on 16/5. And on 21/5/2014, she succumbs to her in injurious manner. And the FIR was lodged on 24/5/2014. This is the sequence now. And the learned trial court, while convicting the appellant, has relied on the testimonies, evidence of PW1, PW3, 4, 6, PW7, and PW8. So, Doctor, allow me to go to the evidence.
P30. Yes.
Lordship will kindly come to the evidence part. If the lordship come to kindly to evidence part, lordship will find the total and the tripod has relied upon the testimonies of PW 1, 3, 4, 6, 7, and 8 lords. No witnesses have stated anything regarding making of any oral lying declaration by the victim in their previous statement. For the first
That
time,
is not contradictory.
because there's the omission. There's the omission which goes to the root of the case. Because had it been a case matter, has been any oral lying declaration, then first in time, a statement was recorded by the IO. And then they did not disclose. And subsequently, for the first time in the court, they have disclosed regarding the making of the dying declaration. In this regard, Lordship, the mandate of the Honorable Apex Court in the case of Poonam Bai, it is very much clear.
Yes.
Just I'm pointing it out. Lordship come to, this is the case of the Uttam versus state of Maharashtra. Here the case of the Poonam Bai has been referred. This case is also more or less on the same footing, madam. Here are two dying declarations, and subsequently the Honorable Apex Court has discarded both the dying declarations. And in this case, Lordship, the case of the Poonam Bai has been referred in para number 35, Lordship.
These witnesses, you have referred that PW three is not an interested. Show me, she is an interested witness.
She was the neighbor, Lordship. Now, just I'm
But
reading.
cannot be termed readily as an interested witness. Who is interested? Who is interested to get the accused?
Lordship. See behind the bars. She is having some vested interest.
Otherwise,
Lordship.
she is a natural witness.
Lordship,
Immediate neighbor indicates her presence or to hear the cry of a lady.
Lordship,
She is in the immediate neighborhood.
Lordship.
She is not directly in the category of interested witness.
If your Lordship allow me, just I'm just reading out.
Here in 389, not,
Lordship, Lordship, not on,
not on.
not on
not
potentiality of the case.
hearing the appeal.
That I do admit, Lordship.
Please keep the distinction
Lordship,
between the hearing of appeal and hearing of 389,
Lordship, Lordship, I do understand that.
right?
Lordship,
That there is a fine distinction between the two.
Lordship. Just I'm pointing out the relevant portion, Lordship.
Because the fire burn injury, that is here.
Lordship,
There appears to be a motive
Lordship.
also.
So far the FIR is concerned.
FIR is concerned. And somebody has also said something, some auto rickshaw kind of thing.
Tempo,
Some
one tempo
kind of
driver. He was the, as per the prosecution case, Lordship, he was the tempo driver.
So how an omission is a matter of trial. Hearing.
Lordship, all the witnesses, Lordship, my only,
But a mother statement was recorded,
no,
161.
no. I think, my lord, 161 was recorded, but subsequently he expired.
Huh?
He expired. Other expired during
No,
the
no,
process.
161 was there. In the case diary. She died during the interregnum, right?
Lordship.
Is it not? What is the name of the mother? Do you have any idea?
Okay, so far the procedural concern also is taking.
Before filing of charge sheet, she expired. What her, what was
Lordship,
her
her
name?
statement is there.
What was her name?
I think Obola Rajbanshi.
Bola.
File statement is confirmed, my lord, the 161. We have stated categorically that the Kishore Pathake খালি হাতেৰে জুই নুমাবলৈ চেষ্টা কৰে যদিও জুই নুমাব নোৱাৰে। মই বাহিৰলৈ দৌৰি আহি ওচৰ চুবুৰীয়াক চিঞৰি মাতো।
Oh, you were there, nearby, from the PW3.
I'm not disputing my presence, my lord, in a place of offense. Really, my only submission is that, my lord. Two witnesses have specifically stated, my lord, that I was trying to save her. Even the mother, Obola Rasbunsi, has.
What is, why that post occurrence conduct? Your post occurrence conduct. After people gathered, why did you flee? That respondent of PW4 has stated.
That is
You
a big,
went on running from the place.
that is a big contradictory, my lord, because what I am saying, my lord, that the PW3 have stated that I was pulling the victim from the pond. She was trying to jump in the pond, and I was trying to, I has covered her with a
You had
blanket.
elicited her from PW3. You had elicited. Defense had elicited. See the cross-examination of PW3.
At the time, the Rita Rasbun Singh was raising, he
No.
tried to jump. In the
We have
pond.
to say, what is the law about omission? So far as PW3 is not an directly, we cannot readily accept that she is an interested witness. She is neither related.
And so far, 161 of PW3 is concerned, my lord. If your lordship kindly.
Show
have
me
a look.
how this omission is to be
That ought to have,
contradiction by diction, contradiction by omission, how it is. to be.
that ought to have been put to the IO, that statement, whether she had stated in her 161 statement. that this is the thing,
Have you done?
but that was not done. That omission part remained, but the contradictions were brought on record, my lord. That was proved.
But the contradiction is by putting the statement to the accused, sorry, PWs.
No, my lord, to the IO. That has been proved by the IO also, contradiction.
No, whether that will,
Omission
that-
was not,
whether that will establish the contradiction or omission.
so for the evidence sake, my lord, it is proved, when it is called proof contradiction, when it is proved to the witness and subsequently it is proved by the IO.
The
After going-
statement was marked. Statement of PW 3, 4, 5, 6, 7, those were marked, those portions were marked. After that marked portion was shown to the IO.
No, see, it was put to the IO directly, the
So
statement.
is it the way? Is it the way? I'm asking you. Is it the way? Proof contradiction.
So in the usual trial, lordship, we used to.
No,
put the
usual trial is no, I am going by this,
Lordship law,
by law.
lordship.
This is happening, this is the convention, we are not on that. If you go right from Tahsildar,
Yes, in the,
right from Tahsildar to all subsequent judgment to Birender and all, how this is to be proved? This is no contradiction as per law. Yes, convention may be. Convention, like the suspicion cannot take the place of proof. The convention cannot take the place of law. For this stage, yes, to proper application will be maybe a case of don't know, any bit of doubt, but so far as for 389 it is difficult. Cannot go into all this, but this is not only suggestions were put. Thereafter, IOS.
it was put to the IO. It was put to the IO.
That cannot be. Convention cannot take. You might have a very good case. If there was no mention about PW seeing PW the accused.
So for the flying over from the place of offense, my lord, also just put a question to me regarding the previous. conduct.
थोड़ी जो देखो
So for
दूसरा मन में
few
you
witnesses
were
have,
found missing. Who have said?
few witnesses have made different versions. One
That
have
is
stated that I have fled away by taking it back through the paddy field. She saw me.
It's just 389 difficult. Yes, madam.
Here is there, here is there. Here is there also. So with the case, if I book it here,
Where is it?
not ready, but this here is there. With this here. also. Here is there.
Yes, Mr. Peters. And it's even. Right, deletion for the opposite party. With the opposite party,
Informant was made in the party.
opposite party number one. An instant application. 1973, by suspension of execution passed against the applicant and for his legal. The applicant, as the applicant has put the accompanying appeal from a criminal appeal number 34 of 2024 to assail a judgment and order dated 22/5/2000 passed against him by the Court of Granite Station from Baksa, Solpur, in Sessions case number 2008 by the judgment and order dated 22/5/2024. The learned trial court has convicted the accused applicant for the offense under section 3 and he has been sentenced to under a rigorous imprisonment for life and to pay a fine of 60,000 for the payment of fine to undergo simple imprisonment for 6 months. Mr. Das that the learned trial court has returned the finding of guilt after an erroneous appreciation of the testimony of the prosecution witnesses, PW1, PW3, PW4,
PW 1, 3, 4, 6,
Six.
7, and 8, madam.
6,
Seven
7,
and
and 8. He has submitted that none of these witnesses saw any incident regarding sustaining of burn injuries by the deceased. First of all, there is no evidence as to as regards the person who had allegedly set fire on the deceased. First of all, it was as per the testimony of PW3 and PW4. It was the accused who had assisted the deceased to come out of the pond.
Always. He was trying to jump in.
Where the other hand come out. They come the application. Has submitted that the deceased has sustained extensive burn injuries on her person. First of it has been established from the evidence of record that the applicant who was present in the house of the deceased prior to the offense and at the time of offense. She has submitted that BW three or the other witnesses. The basis, other witnesses. On, the trial court had relied, cannot be placed in the category of interested witnesses, as contended by the also for the applicant. Also, the PW3 being a neighbor of the deceased and the informant, had seen the applicant and the place. The testimony of other prosecution witnesses had corroborated the factum of sustaining burn injury by the disease and the presence of the accused appellant and the place of occurrence at the relief. We have considered the submissions of the facts of the party. The materials for the relief, the case of sections, case number 53/2019, including the testimonies of the prosecution witnesses and the autopsy report posted as part of the believed incident had occurred on 13/5/2014. First, the FIR was lost according to you,
Was lost on 24/5/2020.
24/5/2014. 2014. The disease expired on 21/5/2014. The place of occurrence, the place as per the postmortem examination, as per the opinion of the autopsy doctor recorded in the postmortem examination report. The date of the disease was due to septicemia following burn injuries, which covered 75%, 80% the total body surface area. From the testimony of the prosecution witnesses, it has emerged that it was in the house of the deceased. The disease had sustained the burn injuries. On 13/5/2014. And as per the testimony of PW3, the incidents occurred in the morning hours of 13/5/2014. So the other prosecution witnesses had testified, had also testified that the occurrence is in the morning was affected. The disease was hard, screaming for help after sustaining, sustaining burn injuries on her person. Having caught fire, the disease jumped into the pond of her, which was in, in the house premises of the deceased. So, as per the testimony of PWC, the applicant was found to be present at that point of time, found to be present in the house of the deceased at that point of time. The other witness the PW4 also. PW4
Dina Medina.
had deposed to the affected. When asked, the deceased told her that it was the applicant who set her on. PW3 had also deposed to the affected. When asked, the victim told them. When asked immediately, after the incident, the deceased told her that it was the applicant who had set her on fire. The prosecution had fought to place a motive by making efforts to bring evidence regarding a dispute about a tempo. The land applicant has submitted that the testimony of prosecution witnesses also go to show had also was also to the effect that the applicant had pulled the disease out of the pond. The conduct of the applicant of leaving the place of occurrence immediately after the occurrence is a factor which cannot be ignored. The learned counsel for the applicant has further contended that the omission made by the prosecution witnesses in their previous statements are fortified by the testimony of the IU. Whether the contradiction of the in the testimony of the prosecution witnesses who are their previous statements recorded on section 161 CRPC is not equal to be common. Is a matter which is to be appreciated and decided at the time of hearing. Have been considered. That's we have also perused the state, sorry, the replies given by the applicant during his examination on the 313 CRPC to find out as to whether he had provided any explanation on perusal, find that there is no proper explanation as regards his presence of the patient time of at the time of sustaining foreign injuries by the disease at her own house. I think on the for the purpose of considering for suspension of execution of the sentence. Come out with this to pursue also to allow application. Such view of being period of free from the prayer means at this stage. On its part, Mr. Pidas, learned counsel for the applicant and Ms. A. Begum, and the additional public prosecutor for the state itself. As the trial court records are received from the registry to prepare the paper book in an expeditious manner. It's the case after 4 weeks for report as regards the paper.
Objection, whether it is come on record on.
Offense.
302-201. It was filed on 2/5. We have received on 2/5.
Witnesses, how many?
Well, also, actually, what happened in this case of
Just number of witnesses.
number of witnesses, yes.
21.
It's actually, it is based on the admission before the police. Confession.
So we are not into merit now regarding preparation of paper.
I go. No, it is a case of equally, there is no eyewitness. Based on only circumstances that we have admitted before the police. That is.
Mr. Economy Learning Council for the appellate. This even immediately. Planet, traditional public prosecutor for the response state. The case records of sessions within bracket as C case number 12/2024. Have been received, so praise to prepare paper. And this, yeah. I heard Mr. P. Kotokil, and counsel for the applicant appellant, Avegom Learned Counsel, additional public prosecutor for the opposite party, Kama State, Sun. It is submitted by the Learned Counsel for the parties that an objection by the public prosecutor on behalf of the state has been filed in connection with this application. Which were on the 430 in bracket 2 comma BMSS BMSS Act number 2008. As the state objection filed on behalf of the state is not on record. Let the case be listed on with the said objection on record. Court of June.
Please, Your Lordship. Lordship, I have come before your Lordship against an order that your Lordship had passed for compliance of that order. The Lordship takes up page 10, my 8. This order was passed on 25/6/2024 in my 389 application. The convict is mentally unsound. Observation was made in my lord, page 15, 15. Paragraph 16, my lord. In view of such observations made by the medical board constituted to examine the mental health of the applicant appellant by Nagaon Medical College Hospital, we deem it proper to direct the mental health checkup committee of District Judge Morigaon to place the case of appellant so and so before the jurisdictional mental health review board at the earliest for consideration of the case of the appellant applicant under section 103 within 15 days. My lord, subsequently, we have been filing representations also, but till date, this board has not sat. In fact, Lordship takes up the green flag in the eye. This letter is addressed to the District Judge Kamrup Metro, who heads the jurisdictional mental health care board.
Yes, Ms. Begum, in para 19, a copy of this order be furnished to Ms. Begum. Take necessary steps from her end. What did you-
Last order also was there for like, there is the order also.
After that, what did you do?
First, we have conveyed the necessary. There is a
It was for expeditious consideration. It was
Within 15 days.
observed paragraph 19. Copy was that served to you, that is why. Now they are coming up with a letter 19/4/2025. There is no mention about the earlier order.
We have conveyed to them.
In fact, the first order that was passed in this eye was of 10/4/2025. Against that, the letter has been issued.
But the district section judge is the chairman.
My lord, as for the acknowledgement. 22, my lord, section.
Mental,
74,
mental,
Healthcare Act. Section 74. 74(1), each court shall consist of, number A, a district judge or an officer of the state judicial services who is qualified to be appointed as district judge or retired district judge, who shall be the chairperson of the court. B, representative of district collector or district magistrate or deputy commissioner of the district in which the court is to be considered. And the Kamrup Metro has jurisdiction over Kamrup Metro, Morigaon, Nolkari, Karbi Anglong, and I guess Baksam.
The superintendent should explain why this order has not been implemented. Earlier order. And how fix a time and place for his appearance before the mental health board. The letter has been written to district and session judge. Any idea?
We have no information. We tried to find out from district court premises.
It is sent to the district judge.
In fact, my lord, the lordship takes up page 17 of my application. This is 24 July 2024. We have written to the district judge for constituting this board. Subsequently, the same, another letter was, a representation was given on 21st of January 24.
Heard Mr. D.K. Boros's learning process. Kent. And Ms. Jivagon learning condition for. The applicant is presently lodged in district jail, Morigaon.
Muri.
In this application, come up. The applicant has posited that he has been suffered and undergoing treatment for schizophrenia for a considerable length of time. When an earlier application, I criminal 168,000 was prepared by the applicant appellate, the said application was disposed of by an order dated 25/6/2024. With a direction. The district jail law, Morigaon authorities raised the case of the applicant appellate before a jurisdictional mental health review board at the earliest for consideration of the case of the applicant appellate under section 103 of the Mental Health Care Act 2017. Within 15 days from 25 2020. Along with the relevant reports, including the medical reports of the applicant. A copy of the order was directed to be furnished to the learned edition of the prosecutor to take necessary steps. Where from Greg a letter from which is a letter dated 2019, which is a letter dated 19/4/2025 of the superintendent district jail Morigaon, addressed to the district and session judge Kamrup Metro, who is also the chairman Mental Health Review Board, Kamrup Metro. I transfer, it is that there is no difference to the order dated 25/6/2024, passed in I criminal 168/2024. Full stop. The said letter dated 19/4/2024 is only in reference to an order dated 10/4/2020. Full stop. In the letter dated 19/4/2025, Superintendent District Jail, Oregon, has requested the chairman, Mental Health Review Board, Government, to fix a date and time, fix date, time and place of appearance of the applicant appellant before the Mental Health Review Board, Cambo, in bracket, Metro, for mental health status of the applicant. In reference to the order dated 10/4/2000. Para. More than 11 months. More than 10 months. Have expired, have elapsed since the order dated 25/6/2024, passed by criminal 162/2000. Para. In the above backdrop, command a superintendent. District. Shall this record. Shall inform this court about the time, date, time and place of appearance of the appearance of the applicant for the date, time, place fixed for appearance. The applicant for the mental health review for Kamru in the metro. So it is stated that the mental health review board from Kamru Metro has a jurisdiction to decide the case of the appellant who is presently lodged in district jail Morning. The superintendent district jail is to explain as to why the direction meets in the order dated 25/6/2000 to explain in writing as to why the direction made in the order dated 25/6/2000 passed in I criminal 164/2024 has not been carried out till. Post of a copy of this order if it is to be furnished to Ms. Recommend application to transmit it to the superintendent district jail immediately. First of, place the case on.
June.
So not 7,
And can it be
7,
four-
6,
can it be
6, 6, 6, 6, or 4, 6.
Logic, logic. I will not be there in 10 from 4 kilometers.
June.
Publish.
Password of 5/2024.
Offense
302, logic, 22 days.
only 302.
Logic.
Yes, madam. But I Learned counsel for the applicant appellate. And Ms. Eva Gom, learned additional public prosecutor for the opposite party. From a state of Assam. The instant application is prepared under section 5 of the Limitation Act 1963, seeking condonation of delay of 22 days in preferring the connected criminal appeal, which is yet to be numbered, which is yet to be registered and numbered. Para. The connected criminal appeal has been preferred by the applicant appellant under section 415 bracket 2 of the Bharatiya Nagaric Act 2023 against the judgment and order dated 29/1/2025
25.
passed by the learned session judge from Bakside, Salpur in sessions case number 02/2018. The applicant pays the trial. You were the only one. Pays the trial in sessions case number 02/2024 for a charge or charges under section 326 and section 302 of the IPC. After trial, learned sessions court is convicted the applicant for the offense of murder under section 302 IPC. And he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 in equal the payment fine, to undergo rigorous imprisonment for another 2 years. Para. We have gone through the statements and amendments made in the instant application from more particularly from paragraph 2 there. Also. Now explaining the cause of delay in preparing the connected criminal. Ms. President, the Additional Public Prosecutor has fairly submitted an instead of the interest of justice will be served if the connected criminal appeal is heard on merits by condoning the period of delay of 20 days, which is not significant. Having gone through the statements and amendments made in the instant application, we are of the view that the applicant has explained a period of delay showing sufficient cause. In such view of the matter of the instant application, seeking condonation of delay of 20 days in the connected criminal stands allowed. The restrict to register the connected criminal bill and thereafter come out to this the same for admission. Notice we heard Mr.
Yeah.
Ahmed. Council for the applicant appellant. And Miss Eva Gomes, 302.
302 units.
Hmm?
302 units.
And Miss Eva Gomes. And additional public prosecutor for the party number. Some. Recent application is prepared. Seeking suspension of execution of sentence passed in the in sessions case number. Sessions will be T-1 case number 98/2020 and for his release on bail. The applicant has been convicted by a judge in order to take it. ID 4/1/2020. Filed by the London Sessions Judge Nogam in sessions within bracket T-1 case number 98/2020. And he has been sentenced to under section 302 IPC, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 20,000 with default stipulation. Issue notice returnable in courts as Miss Begum tradition. Here and itself. Now, opposite party number 1 must take some issuance of program. Just say. But if he
Appeal has already been admitted, your worship. Later on, I have filed this. There, the notice has been served. Your worship.
the connected criminal appeal. Criminal appeal number 63/2020. Notice was issued to respondent number 2 on 21/2025. And as per office note dated 16/5/2025. Recorded in a case record of the same criminal appeal. Notice upon the respondent. The direct public prosecutor self-filed objection to this application on a report that it can. Appeal. Mr. E. It. And it counsel for the appellant and Ms. A. Begum and the additional public prosecutor for the respondent state post as the request from the London trial court have been received from our office to prepare the paper. Place the case after place the appeal after 4 weeks for in respect of proposals.
There has been filed. Under
Notice has to go.
It is an
Artist-
appeal against.
Somebody is acquitted.
Yes,
Let him come. Heard Mr. You are legal counsel.
legal aid counsel.
Heard Mr. Chudri. Learned counsel, learned legal aid counsel for the applicant. And Ms. A. Begum and additional public prosecutor for the opposite party number 3 from a state of Assam. First of, the instance application is prepared under section
413.
413.
Again.
And there is a provision for condition delay.
Worship.
I am not
413 there.
not familiar with PNSS, that is why.
413 is the 372 of the earlier.
But condemnation is under section 5 always.
Yes, yes, condemnation is always. Condemnation there is. no.
I thought that there is a
No.
provision, I think.
No.
Okay, because I'm not very
Condemnation,
familiar with BNSS. Yeah? If I know the equivalent provision, then yes, everything comes in mind. Seeking condemnation of delay of 58 days in preparing the connected criminal bill. Which is filed under the proviso, I think, under the proviso to section
413.
413. Not in the substance. No. 413, Bharatiya Nagarik Surakshita Samhita 2000. Issue notice returnable in 4 weeks. As Miss Begum. And additional problems present yet and accept some job. Issuance of funds. Receipt, the party is expense which applicant shall take step for service of this up in the opposite party number 1 and opposite party number 2 by registered post AD as well as by your process within 2 working days.
Lovely.
This reward to civil paper, due to some close relative of bad number. So we have
So, close relative, okay. Please ground, but whether she'll not be able to come
given
for,
next half season.
no, no.
The commission.
no, there are some relatives for which, whose dates the person may not come for next 1 week or 2. Or, okay, then we can look at his submission. At least there is nobody otherwise in the court. Okay, we'll hear this one also, other one also. Okay, let us be taken to the FIR process.
Page 4.
One by one sequentially so that.
Yes. Page 4. Humble submission is that around 3:30 PM yesterday, on 8/8/2009, residents of our family, namely Shri Vijay Krishna, Shri Vishal Krishna and Amit Krishna, P.T. Krishna, who are brothers, got engaged in an altercation with Shri Dasaru Kanti, a resident of Mankoa Tea State, Premnagar, Basti, as well as elder brother of my wife over the matter of domestic affairs at line number 15, and they assaulted him and caused grievous injury on head and face of Dasaru Kanti. As a result, he died on the spot. His mother, Paikon Kanti, was also assaulted along with him, and therefore requested him to take necessary.
His brother-in-law,
Yes, ma'am.
informing his brother-in-law.
His brother-in-law. Accordingly,
Date is 8/8
yes, ma'am.
and FIR is lost,
The fire lodged on 9/8/2009,
incident 9th. 10:30.
10:30.
Right.
Thereafter, Lord, charge sheet was submitted against
Let us see our seat.
all the accused.
One minute. Sar seat,
Those 99. Okay,
19. When was arrested? When? Any idea? From the LCR or TCR? Charges filed against how many?
All the
Name
four,
and
four
address
accused,
and
one of the accused was absconded,
let us see the last part. Against all four.
against all four.
Against all. Yep, first part of the test.
Thereafter,
1 minute. Vijay, you are
Vijay Krishna.
Vijay. To Vishal. Into 30 absconded.
Absconded.
Then Vishal Krishna juvenile.
Juvenile.
Then means
Charge
SARS.
was framed, page
Where is the
six,
SARS?
page 6.
Page 6. Okay, 1 minute. The commitment order.
Yes, commitment of order, page 6.
Bureau's PA against absconder. Commitment order, page 7. 14 by commitment. Yes, Begum, what is E stroke O? What does it stand for? I have forgotten. Issue notice to the EO in a commitment order. Inquiry.
Inquiry officer. The charge was framed against two.
1 minute. Read the commitment order. Pinku was declared absconder. Why? Because we cannot make much comment on Pinku. That is why I am looking at.
He was
I can, while
That is
deciding your MP, I do not want to make much comment on Pinku. That is why I want to see what is going on. If I declare also Pinku,
no.
right,
Yes.
there are some difficulties, so I cannot consider your case exclusively. I have to see also
Yes.
who are the persons involved,
Yes.
who is a juvenile, all this have to be seen. Oh. It or on it.
Only Krishna. 。
And who is the charge?
Page 6.
Six. Date of charge, 9.
302W.
Under section
302/34. Oh, good.
302. Judgment. How many witnesses were examined?
Total 11 witnesses.
Last page of the judgment. 11 PWs. 11 PWs. DW also. No, DW. DW. Three DW. How many exhibits? 9 exhibits. What is the judgment?
Taking over is at page 51.
What is the result?
No, conviction and the
No, no.
one of
Both or?
only one.
Tell me that.
Vijay Krishna, page 66.
Which
paragraph,
which part?
Page 77, my lord. Page
No, no,
66,
finding him, acquitted, finding this.
63.
Paragraph
Acquittal of Amit Krishna,
paragraph 58. Paragraph 58 is only because paragraph 58 is the finding, so it is no equity. Vijay Krishna Pandit. Where is the sentence? Under section 302.
02.
Alright,
That's 66.
line. Right. Yes,
The basic case, my lord, here is that entire case was based on circumstantial.
just see, sir, all the
And-
witnesses,
Yes, my lord.
there is no shortcut in a case,
Mhm.
at least for me, I'm not of that intellect.
Yes, no, my lord, I'm
Huh?
just telling the one basic what I have read. that It's
Circumstantial.
a case of a circumstantial evidence, my lord, no eyewitness. My lord, I will start from PW1, page 9.
Yes, please.
Page 9, my lord, PW1 is the doctor, my lord, who has conducted the postmortem report. My lord, his evidence, if I may read, my lord, on 9/8/2009, I was working as SDM in HO at Tinsukia Civil Hospital and did the postmortem on the body of Basaru Kanti, 40 years, male Hindu, wife Indoma, 3S case number 303/9 under section 302/341 IPC on been identified by Constable Param Gogoi and one of his relatives, Surjay Mohan. On examination, found male body of average build about 40 years wearing red onesie and cream color full pant. Injuries are lacerated injury over left parietal region, 2.5 inch in length and deep into the brain with fracture of parietal bone and subdural hematoma. Hematoma. Second is lacerated injury behind left ear, 2.5 inch in length, bone deep and subdural blood collection. Third is lacerated injury in front of left ear injury, maxilla. No other injuries are detected. In my opinion, the death is caused by coma as a result of head injuries sustained. Approximate time since death 18 to 24 hours. Number one, injury is sufficient to cause death of a person in the ordinary course of nature. Exhibit 1 is the PM report, exhibit 2 is my signature. So, my lord, the nature of injury as, my lord, uh, given by the
Injury number one is sufficient to cause
sufficient
death
to-
in on the ordinary course of nature.
Yes,
Clearly, it is a homicidal.
yes. The injuries mentioned in my report may not be caused by falling or due to hit by any substance, as these injuries are always homicidal, neither accidental nor suicidal. I have not mentioned in my report.
So cross-examination, it was more elicited.
Yes, yes. Ma'am. I have not mentioned in my report that in which part of the body of the deceased rigor mortis appeared. In the summer season, rigor mortis appears in the dead body after 6 hours and it continues to be for 8 hours. It is not a fact that rigor mortis appeared after a period of 6 months and continues up to 48 hours. Thereafter, my lord, the PW2, who is the mother of the deceased. Her statement is at page 11, evidence is at page 11, my lord. Shrimati Taikon Tanti. She has stated that I know accused Vijay Krishna alias Mela, Vishal Krishna alias Bam, Amit Krishna and Pinku Krishna alias Tinku. Dasaru Tanti was my son. It has been about 3 years since the death of Dasaru Tanti. On the date of the incident when my son Dasaru Tanti was returning home after completing his duty, Vijay Krishna, Vishal Krishna, Amit and Pinku of line number 15 together killed him by assaulting with iron rod. At that time, I was at home when a person by the name of Dil Bahadur raised alarm in the street. I came out of my house and when I asked him, he replied that Mela, Bomb, Hanif and Tinku together killed the Sarutan.
Nil Bahadur is a witness?
No,
No.
we have not been.
Okay. Hmm.
So, immediately I went to the place of occurrence and I saw that my son was lying on the road with injury on his head and back, and subsequently I became unconscious. After a few moments, I regained consciousness and found that I was at my home. My son-in-law Suryakanta Tanti lodged an Ezhar with the police station in connection with the incident. Although police took away the dead body of my deceased son Dasaru, they handed it over later. Prior to some moments of the incident, Tinku slapped me twice, and at that time he was armed with an axe. The police examined me regarding the incident. In cross, to the court, my lord, it is written that she has given a statement. The wife and a daughter of my deceased son, Dasaru, are still alive. They do not have any source of income at present. Age of Dasaru's daughter is 8 years. She does not go to school due to her poor condition. Now in cross, my lord, Dasaru's wife stayed in Odisha for about 15 days and at present she is staying with me. Letter says that Dasaru's wife stayed with me for about 15 days and she stayed in Odisha for the rest of the days. Since my daughter-in-law stayed in Odisha, my son Dasaru got married with a girl from Jaipur and kept her along with him. But she returned to Jaipur prior to 1 month of my son's death. Dasaru's first wife has not returned from Odisha till now, who went to attend Raksha Bandhan ritual. Police has not arrested the accused of this case including today. After the incident, I met Dil Bahadur in line number 15. The place where Dil Bahadur told me about the incident is situated about 400 yards away from the place of occurrence. The house of Dipali and Arjun are situated near our house and there is no other house on that road. Now, this is also important because these two witnesses are also not examined, nor as per the sketch map, these two persons' houses are there. If one has to go to the house of the accused, he has to take the bylane which comes before the bylane leading to our house. The distance between the houses of Amit Krishna and Vijay Krishna is about 30 feet. It is not a fact that houses of Amit Krishna and Vijay Krishna are located at a distance of about 2 furlongs from my house. It is not a fact that I stated before the police that Pinku Tanti had killed my son
by assaulting with an axe. I did not state before the police that Dil Bahadur raised alarm, saying that Amit Gom, Mela and Tinku Kanti had assaulted my son with the iron rod. The time of the incident, I was cooking food in my house. It is not a fact that Dil Bahadur raised alarm saying that Anil Gom, Mela and Tinku alias Tinku had assaulted my son with iron rod. It is false. Remember, this is the statement of PW to the mother of the deceased. Now, note PW3. The statement of PW3, PW3 is Sujya Mohan Kante, the complaining who has lodged the FIR. Note he in examination in chief has stated that I know both the accused persons, namely Anit Krishna and Vijay Krishna. I know the deceased, the Sarut auntie. The Sarut auntie died about 4 years back. On the day of the incident, I came to know that the Sarut auntie died. On the day of occurrence at about 8:30 p.m., when I was in my shop, a quarrel took place between the Sarut auntie and Vijay Krishna. And at that time, Tinku auntie, Bom alias Vishal Krishna and Maina came to place of occurrence and they asked me to settle the dispute between them. Then I settled the dispute and left the place after closing my shop. After a few minutes, one person named Dil Bahadur Narsingh, again he is also named, came to my residence and informed me that the Saru was murdered and the dead body of the Saru was lying nearly near the house of Bish Kishore Shah and Usman Tanki. Then I rushed to the place of occurrence where the dead body was lying and I saw the dead body. Then I came to the manager of the tea garden and informed him about the murder of the Saru Tanki. The manager told me to inform the matter to the police and accordingly I lodged a written izhar for Dunduma PS. Exhibit 6 is the izhar and Exhibit 6(1) is my signature. Later on, the police came to the place of occurrence. Police prepared the inquest report and I put my signature thereon as witness. Exhibit 2 is the inquest report and 2.5 is my signature. When the incident was committed, Mom alias Vishal Krishna, into Vijay Krishna and Naina were present, but the accused Amit Krishna was not present, so I suspect that the above named accused person were responsible for killing the Saru Tanki. In the cross-examination, my lord, PW3 has stated, I have not seen the assault caused by the accused person. My shop was situated about 15 to 20 feet away from Pinali, where the occurrence took place. I have not stated before police at the time of recording my statement by police. I have not stated before police that I was in my shop at the time of the incident. But before the police, I have stated that at the time of incident, I was at my house prior to reaching of Pinali from my house. The houses of Vinita and Vikia are situated. After quarrel, Vijay Krishna as stated earlier, after 1 hour of that quarrel, Dil Bahadur Narsingh was informed me about the incident. I have stated before the police that while I was in my shop, one bomb into Vijay Mena came to the place of occurrence. It is not a fact that I have stated before the police regarding the presence of bomb Krishna Tinku and Nina while I was in my shop. The deceased was my brother-in-law, that is son of my mother-in-law. It is not a fact that I have not stated before the police that my mother-in-law informed me that the accused had murdered the Saru Tanki. I have indicated the accused out of suspicion. Now, Lord, PW4. Usman Tanki, my lord, his house is nearby the place of occurrence as per the sketchman.
What is his name? Asman.
Usman Tanki, my lord.
Asman.
He has not Similar, any statement being probably correct, near to the place of occurrence.
Anybody mentioned that his house is?
The IO in the sketch map, has pointed it out. Page 90,
Vinita Vakia.
page 97.
Vinita.
He has also stated that the road was lying on nearly near the house of Kishore Shah and Asman Tan.
One, what is that? Page 3
PW3, page 15,
is 15.
8 line from the top.
Asman.
7th line. After the few minutes, that line. After the few minutes,
PW, the Osman Raji is PW4.
Asman Tan is PW4.
Oh.
PW4 stated that I know both the accused persons, namely Vijay Krishna and Amit Krishna. I also know the deceased Dasaru Tanti. Dasaru Tanti died about 3-4 years ago. On the next morning, I came to know about the death of Dasaru Tanti from the people of our line. I heard that the accused Vijay Krishna and Amit Krishna, along with others, caused the death of. In the cross-examination, he stated, I have only heard regarding the incident, but I cannot say exactly who informed me regarding this matter. Only there was Allah, the implication of the accused in our locality. Thereafter, my lord, PW5, Ratan Tanti. His house was also near the place of occurrence, as per the sketchman by the IUM.
PW?
5,
Fine.
Ratan Tanti. Statement says, that I know both the persons, namely Vijay Krishna and Amit Krishna, and I also know the deceased Dasaru Tanti. Dasaru Tanti died about 4 years back. On the day of occurrence, my wife Usha Tanti informed me over phone that Dasaru Tanti was murdered by some person. On the next day, I came to my residence and found blood stains on the road, and later I came to know that Dasaru was murdered by Vijay Krishna and Amit Krishna. After 2-3 days of incident, I could learn from the villagers that Vijay Krishna and Amit Krishna caused this murder. Now, coming to the statement of PW6. His name is Mukhya Tanti. The neighbor, my lord, neighbor near the place of the occurrence. She has stated that I know the accused person. I knew Dasaru Tanti. He died 3.5 years ago at 8 p.m. on the date of the incident. Hearing hue and cry on the road, I came out. I saw Dasaru lying dead in the line number 15. Later, I heard that the accused persons had killed him by assaulting. I saw injury and blood in Dasaru's head. Police came and took away the dead body. In the cross-examination, she stated that when I was at home, I came to know about the murder of Dasaru. Dasaru's mother informed me about it. I went to see the dead body after the police had arrived. At 10 a.m., I went to see the dead body. I do not know how the murder took place. Now, Mukhya Tanti, she was also having the house near the place of occurrence, which is revealed from the statement of PW3. In the cross-examination, PW3 stated, my lord, that I was at my house prior to reaching of Pinyali from my house. The houses of Vinita and Ukya are situated. Now we are coming to the statement of PW8. And he is also the neighbor. No, he has not stated anything. When I know the accused person, I know the deceased. The Saru died 3 4 years ago. I do not know how the Saru died. Police came but did not interview me. Cross-examination was declined. Now coming to PW9. PW9 is one of Brij Kishore Prashad. He is also the neighbor. I know the accused person. I also knew the deceased, Zaru Tanti. He died in the year 2009. On the date of the incident, I was at home. After 4 5 days of incident, when I returned at my residence, I came to know that scuffle took place between the accused and the Sarutanti, and for that reason, the accused committed murder of the Sarutanti. I do not have any personal knowledge regarding the incident. Police did not record my statement. And my lord, it has also come from evidence that in fact it is near the house of PW9 that the dead body was found. The dead body was not was found near the house of the PW9. This is also stated in the statement of PW3. PW3, the line which I read earlier, that after a few minutes, one person named Bin Bahadur Singh came to my residence and informed me that the Saru was murdered and the dead body of the Saru was lying on Kinyali near the house of Kishore Shah and Asman Tanti. We are now coming to the deposition of PW10. PW10 is the IU of the case. Here. The statement is, my lord, that on 8/8/2009, I was working at Dunduma PS as attached officer. Then the OC of Dunduma PS, Shri Muni Mohan Ponch, has received one information from the informant Shri Sujat Mohan Tanti, Shri Vijay Mura, and Ajay Tanti of Manopur T State Line number 15, that the Saru Tanti has been killed by Amit Tanti, Vijay, and Vishal Tanti. Accordingly, the OC endorsed me to charge of investigation. I visited the place of occurrence 12:45 midnight and inspected the place of offense. I found the deceased, the Saru Tanti, was lying dead, and the Kinyali of Manopur T State Line number 15. I prepared the sketch map of the place of occurrence on that day. Exhibit 7 is the sketch map. Exhibit 7-1 is my signature. I informed the magistrate for inquest. Magistrate carried out the inquest. Exhibit 2 is the inquest report. Exhibit 2-5 is the signature of the magistrate, which I recognized. I recorded the statement of witnesses at the place of occurrence. I recorded the statement of Shri Sujya Mohan Tanti, Shri Asman Tanti. On 9/8/2009, Shri Sujya Tanti had lodged an Azahar before the police station. Accordingly, the same was registered by the OC. Exhibit 6 is the Azahar. Exhibit 6-2 is the signature of the then OC, which I recognize. I examined the informant at the PS. I again visited the place of occurrence and examined other witnesses. Srimati Okya Tanti, Shri Ratan Tanti, Shri Vijay Mohan Shah, and recorded their statements. These all 3 witnesses, Okya Tanti, Ratan Tanti, near their house, the dead body was found and the quarrel took place. Then, my lord, in the chief, the IU further states that on 9/8/2009 at 11 AM, the dead body of the Saru Tanti was referred to Tinsukia Civil Hospital, Tinsukia, for postmortem examination. I also forwarded Srimati Paipan Tanti to the learned court of Tinsukia for recording her statement under 164 CRPC. Accused Vijay Krishna alias Mela, Vishal Krishna alias Bomkanti, Anit Krishna were arrested and examined and recorded their statements. Accused Tinku Krishna alias Tinku was shown as absconded in the charge sheet. Vishal Krishna alias Bomkanti was juvenile. Thereafter, I collected the postmortem report of the deceased. On completion of the investigation, I submitted the charge sheet under section 30234 IPC against the accused persons, namely Vijay Krishna, alias Mila Vishal Krishna, alias Bom Kanti Amit Krishna, and against accused Tinku Krishna, alias Tinku, showing he was absconded in the charge sheet. Exhibit 8 is the charge sheet, Exhibit 8 is my signature. Now, in the cross-examination, my lord, the IU stated, I received the information regarding the incident on 8/8/2009 at about 12 midnight. I have not submitted the extract copy of general diary entry number regarding the information received about the incident. I visited the place of occurrence at the same time, but as per the sketch map, it was mentioned as 9/8/2009 and no time was mentioned in the sketch map. I conducted the inquest in the dead body on 8/8/2009. Till 8/8/2009, no case was registered regarding the incident as FIR was not submitted by the complainant. The inquest was conducted at Monopoa Tea Estate. The identification mark of the deceased was on right side. One executive magistrate Chief Vipul Kumar Das conducted the inquest at Monopoa Tea Estate on the dead body of the deceased. I have not recorded the statement of Chief Vipul Kumar Das. Near the place of occurrence, the houses of Shri Ratan Tanti, Shri Brijmohan Tanti, Shri Asman Tanti located. This is important. Near the place of occurrence, the houses of Shri Ratan Tanti, Shri Brijmohan Tanti, and Shri Asman Tanti was located there. At the time of alleged incident, all the three witnesses were inside their house, and no one were the eyewitness to the incident. Nowadays, my lord, strictly thinking about the quarrel. It is not a fact that at the time of incident, the complainant was not present at the place of occurrence. It is not a fact that at the time of incident, the complainant was in his shop. I have not sent Shrimati Prakon Tanti for her medical treatment. Shri Prakon Tanti stated before me that Tinku Tanti assaulted my son with her ex, with her, except this person, Shrimati Prakon Tanti, has not narrated any name of others. Except the statement of witnesses, I have not found any other incriminating material regarding the presence of the accused in the place of occurrence. In 164 CRPC also, the victim confirmed that Tinku Tanti had assaulted her son with X. No one of the accused disclosed regarding their involvement regarding the alleged incident. It should be none of the accused. Instantly, I rushed to the place of occurrence after getting the information but not found weapon of assault from the place of occurrence. I have not recorded the statement of Dil Bahadur Narsingh in this case. It is not a fact that I have falsely submitted charge sheet against these Vijay Krishna, Vishal Krishna, and Amit Krishna. The incident took place in the night hours. The place of occurrence was dark. Thereafter, my lord, PW11 is the witness, my lord, is the magistrate who had recorded the 164 statement. She was also examined.
But to that witness that 164 statement was not exhibited.
It was not properly recorded, my lord.
No, the
Yes.
witness whose statement was recorded under
Yes.
section 164,
My lord.
when she was examined as PW2, that 164 statement was not put to her.
Yes. But the IO has.
IO said, but what is the purpose, 164? Is either for the purpose of contradiction or for corroboration. If that statement is not put to the accused, there is what kind of value to the, by putting it to the IO or the magistrate, examining magistrate? The lady was not So 164 is for the purpose of contradiction or for corroboration. That lady was not shown the previous statement. So after examining the judicial magistrate and the IO, for that purpose, what value will be, can be added? No value. She was examined as PW2 perhaps. I have seen. That was not exhibited. So how his court witness will support the case? Now let us see the reasoning given. How? Oh yes, DW, why? This is your witness, DW1.
PW1 is one of
Huh?
the accused.
Your witness.
He is one of the accused, yes.
No, yes, one of the accused. Your brother.
Brother.
See what he has done in his cross-examination.
In the cross-examination, may read the entire,
I have seen,
No.
he has taken the plea of alibi,
yes,
right?
yes,
But what he has done to you?
yes. The incident took place on 8/8/9. There was a clash between wife of Dasaru and Vijay Tanti. On the next date of incident, police recorded my statement. Exhibit 9 is the statement given before the police. I have not seen the occurrence of beating Lathi by Vijay to Dasaru. This is also there, madam. Although incident has taken place,
Because Bijoy came injured, he said. Right,
That
I
will
met my brother Bijoy Kanti on the way of factory in injured condition. My brother told me that Dasaru Tati had inflicted knife injury onto him.
that correlation.
He wants himself to be extricated and he wants his brother to be implicated.
But one, Amit Krishna, Tinku Krishna was absconding, my lord.
That is a different thing. Only Krishna says, as DW1 in its chief.
Yes.
I met my brother Bijoy Tati on the way last night.
Whether, my lord, the injury, the assault on the deceased, that no one has seen. And Tinku Tanti, who is absconding, my lord, perhaps he was the,
This is your witness. You have brought him in. This
this
DW1.
proves,
You did not enter into witness box. You have pushed your brother as DW1. DW1 disclosed this,
quarrel is proved,
which
injury,
none from the prosecution had deposed. Your brother had.
but the question is not who inflicted that fatal blow. That is,
Question is different.
it
DW
may be some
prosecution
other
witness,
person also.
but the prosecution did not bring on record for examination. You by adducing evidence. Because you said 313, I lay this. Your brother said, I lay this. And you have brought, instead of you have put your brother in a witness box. And through him, you have said, I was also injured, so and so. Right? Through him, you have said. And Dasaru inflict. What is the necessity?
Assuming his PW1 statement to be true, only quarrel is proved. That
No,
fatal
chief,
Occurrence of
chief.
on the that date. On that
Chief
date,
last line.
my brother told me that Dasaru had inflicted knife injury to him.
Sometimes defense counsel has become too smart. When they show their smartness, it is at the cost of their clients. what is the circumstances this, the trial court has brought in? To link the homicidal death of the deceased with the accused.
Appreciation starts from page 68, paragraph 45. Appreciation of evidence. Paragraph 55 of the rule. The application by the London trial court, upon hearing both the sides, I have gone through the material evidence on record. The PW 2, 4, 5, 6, 7, 8, and 9. They are not the eyewitness to the incident. There is only one eyewitness, that is PW 3, who saw that before the death of Dasaru few minutes ago, there was a quarrel going on with the accused Vijay Krishna and the deceased Dasaru near his shop. The PW 3 has deposed that as he was asked by Tinku Tanti, Vishal Krishna and Meena to settle the dispute between accused Vijay Krishna and the deceased, he settled the disputes and left the place after closing his shop. But a few minutes later, one Dil Bahadur Nursing went his home and informed. And this is very important.
Okay, follow again for 10 minutes. And your submission. Your submission is to be controverted by the learned public prosecutor.
Regarding lordship, the last century, it applies as because lordship. Last century, the PW lordship,
You go back to 3 perhaps.
lordship, the shopkeeper lordship, PW 3. When there was a fighting.
When a
quarrel-
dispute,
Dispute.
you have looked at the dispute. But where is the settlement? There is also a settlement.
There is a settlement. That is carried by PW lordship, that is gathered in dispute. The need is the circumstance lordship,
That part,
lordship. That is corporate by the PW, that something serious has happened, he was injured, that is their lordship. And lordship, mother lordship, PW 2. They have observed, no, somehow lordship, when they had seen the,
where is Dil Bahadur?
Main person who is not.
their lordship, that two more,
Dil Bahadur
father and one more
informed mother and the brother-in-law informant,
lordship,
but he is missing.
is this,
But I will recorded his statement.
161,
I will say,
lordship. PW 10.
perhaps seen the, some have seen Dil Bahadur.
lordship.
You are the material witness?
He was the
Where is the PW? In.
PW 10.
Dil Bahadur there or not? No, he was not there.
No, no.
Dilbar was not there. Okia Rotondadi Brismohan, record address state. Dilbar is missing. Dilbar, where is the Sarsit?
Page 19.
Yeah, five, yeah. Dilbar is again missing. So you have put PW2 and PW3
PW.
and put
Lodge.
that they were,
There was some quarrel. There was a
they heard it from Dil Bahadur. That quarrel took place. They went to the place of occurrence. They found lying, the disease lying on the road with injuries, so and so.
Okay.
But this is quite a hearsay. And when Dil Bahadur is not examining, that part is missing. Now the quarrel.
Yes.
Then thereafter settlement also.
settlement.
And they were not,
After 10 minutes of settlement,
no, 1 hour. This man,
PW3.
PW3, see,
No corroboration also. PW2, 3.
PW3,
No logic.
minor
Then I
came
settled
place, they
dispute
asked me to
based on-
settle the dispute. One person, because he came to his residence.
One person gave the
No, then I settled the dispute, left the place after closing shop. Now come to the,
difference, one person.
Ah.
One.
In cross, it is 1 hour. In cross. it
in
is
cross, after 1 hour of that quarrel.
Quarrel. Dil Bahadur.
Dil Bahadur said, inform him. Here it is few minutes. Dil Bahadur. And see the information, please, at what time he informed? Ayog, midnight. 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 Quarrel at 8:30. Quarrel at 8:30, right? Then
Place of offense of 12.
IO came to 12:45. He was informed at midnight. I think at what time?
12 midnight. means
12 midnight. So 12 midnight. Regarding he said 12 midnight. This PW3 said, and the manager told me to inform the matter to the police. Accordingly, I lost the affair. That is a different issue. But he informed about telephone. He said, I will say, in chief. I was working so had received one information from informant Sujya Mohan Tati, C. Vijay Mura, Ajoy Tati has been killed. So this GD entry was not executed. But he said at midnight. So 8:30 quarrel, settlement. Then he said after few minutes. And in cross he said after 1 hour. Right? Then thereafter at midnight he informed. So it is about three and a half hours. And it is not that they left together after settlement. Just see, PW3. It is not the case that the accused and the deceased left the place together. Nobody had seen it. Because last scene, theory to come in, both should
They put this together.
be together, both were seen together. Neither PW3 seen, had seen, leaving his shop. It is not there.
Quarrel took place between the Soul country and Vijay district.
Hmm.
At that time, the two countries came out, place of offense, they asked me to settle the dispute. between them. Then I settled the dispute and left the place after closing my shop.
He's not saying that both of them lived together.
Then I settled the dispute and left the place. Left the place. What
Some gap is there.
dispute? And so, the settling the dispute. The fifteen of left the place.
Then I settled the dispute and left the place. He himself.
After it is.
He's not saying.
Because
His gap
only he
is
has
to be
settled
filled up by whom? By the defense or prosecution?
But because they have only settled. And he himself don't know whether they were together. For 2 minutes.
Last in theory is to be put to the hilt. 3.5 hours gap. 1 hour inside his house. PW3.
Let's settle 1 hour.
But nobody has seen.
Then who are you to say?
No eyewitness, nobody has seen. And you are stressing, the prosecution is stressing about the dispute. But at the same time, you have missed that the dispute is settled. We have to go by the evidence on record. We cannot go for surmises, conjectures. You can take a flight everywhere by surmises and conjectures. But our problem is that we cannot take the help of surmises and conjectures. We have to decide the basis what the prosecution has offered on our plate.
Because the only cases of the Mother's Day, then PW3. That is there, and one like is there that we have similar. We cannot say that.
We put it at 10:30 tomorrow, we'll take it out.
But normally, maybe they also.
The 10 minutes, we allow them to. 10 minutes to Mr. Gupta, 10 minutes to, so that Ms. Puya can hear your submission. Only few points. Whether last in theory to get and theory can be brought in. Right? And what are the requirements to bring in last in theory to be. That is one, because the trial court has brought in that part. Right? It is homicide, without about it. But question is to connect the dates.
Quarrel, what has been proved is the quarrel.
Yes, quarrel.
The last in theory has
But
to.
quarrel, whether the quarrel leads to the murder,
Yes.
that
That
is
is the
a distance, that distance is to be traveled. Not by surmises and conjectures. By valid legal proof. That whether that distance is covered or not, that is the issue.
What it is,
Otherwise, if two hypotheses is possible, will not be with your side.
one thing is also there were injury. Injury number one is sufficient to cause it.
So there is no doubt about it. We'll do. It is clear
I
that
don't think that whether.
it comes under thirdly of section 300.
On the latest judgment, on the circumstantial paragraph 30. Five. Clause number 3. Can you read it? Each of the links of incriminating circumstantial evidence should be meticulously examined so as to find out if each one of the
It comes to be
circumstances.
75, sir. 75. That is locus classicus.
Paragraph 74.
Page 75 of the paper. That has attained the status of locus classicus.
The picture, yes.
This is the
Yes, that is a
classic,
little case.
classical,
Classic,
La-
yes, yes,
this is tasted
yes.
everybody.
This is further it elaborate. This has been discussed and
Have you seen Sarat Bidisan?
yes, yes.
That you are saying that this is elaborated. Sarat Bidisan, see the paragraph is not there. This will be paragraph 155, sir.
Yes.
156.
Yes.
You are quoting paragraph 30. Right?
Yes.
And this is paragraph 155, 156 of Sarat Bidisan. They have reached this view after 150 paragraphs. Right?
Case 31 of the logic one, more things that in the cross murder, the incident experience showed it. There was a clash between the wife of Dasaru and Vijay Tandon.
Why?
Wife. Wife.
That does not.
No, no, lordship. But in Dasaru's wife of Dasaru. So there is a reason, there is a behavior. The quarrel, for the quarrel.
That PW2 is saying, why it is not saying? Hmm? PW2,
What's it?
have you seen? Hmm. So doubts. Hmm. Right. Very good stuff. Everyone, addition public prosecutor. Is the case. Again, consequence as part of. Just start your one. Item number 18. Yes.
Okay.
Offense,
Offense 302. Life imprisonment and 1,000 in default.
FIR. Yes. FIR.
Yes, sir.
Yes, your normal voice.
The FIR is dated 29/2015. It says,
humble submission is that about 3:30 on 29th 2015, when my younger brother Bakul Prince was going to bring back the cattle from the seed bed located in the middle of the battlefield in front of his house, neighbor Butai Bhumis, son of Solomon, killed him brutally by hacking with a naga dog in the neck as well as different part of his body without having any reason. I therefore request you to take necessary action against the aforementioned murder upon investigation into the matter. It has been lost by PW6 man, Kalidas Police. And accordingly, the FIR was registered by his PW6. The dead body was accompanied by UDC Commissioner for the Safety and related to dispute and control unit and typically unit experiencing with transaction of activity and final code brain method sequences into one entity. Secondly, one stress injury in the right core both bones fractured because they need one into the third injury, one stress injury in the left core arm with underlying bone transfer either being the brain fourth injury, one stress injury on the right side, just about the insulted. Size of the wound is 1 inch. Stress injury on the left side. Size of the wound is 6 inches into 1 to 2 into 2. The injuries are insulted. The injuries are injured of the surgeon according to the saving self in my opinion, cause of death of the deceased is due to coma as a result of severe physical. It is one of the patients in the disease. It is common. Hi, brother. My, the deceased person is the appellant. Why? Because it's my brother. The case entire is on the final appellant. The full unit was acted and used to stay in the residence of Mr. That's one of the points of order. The case has inside as his wife. His daughter was complete. I cannot say why the full unit left the house of Mr. I have no knowledge of any quarrel between himself and his wife. For leaving the house, going to bring back the car, the full proof one two. No otherwise not say any quarrel. It is not a fact that at the time during he used to take service from the field in South Field. So in this case, it is even when we stay near our station, we saw that it is because in the United States, because in front of us, the state also papers for the new clear. If my solution not going to respond, I think in her chief, okay, he was a supported person to work, whether it was that is not real to the good thing. Technology and health something. Continue to continue also new to me. That and the people coming home from who from outside, saw that some people were standing and watching something, and my aunt something unique told me that my maternal uncle, Mr. William, had killed my uncle. So my wife told me that my uncle had been killed. That my maternal uncle, Mr. William, killed my uncle. Not, but I went to the place of the killed my uncle also the victim and saw that the dead body of the Gokul Boni person for injuries on his person was thought that my mom, people said that one way to clear it, and then the doctor also this and police came with him 300 meters from the police took one doubt and measured it. It says that it is one of the things which I think police also conducted research on the death injury now and the case in the story police also got some statements according to the given case was not a good his aunt told him to familiar to leave the place. He said in the to decide Gokul Boni to the student was killed by the state so that he was too risky of saying it is not a